Stand.
If you'd stop here briefly.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
Please have a seat. Ms. Shervanek, please proceed.
Yes, Your Honor. Good morning, ma'am.
Morning.
If you could state your name and spell your last name, please.
Christina Miller, Miller.
Ma'am, what do you do for work?
I am a divorce attorney, special master, private guardian ad litem, and just started doing divorce mediations as well.
How long have you been a divorce attorney?
Almost 30 years.
And in that practice, do you do exclusively divorces?
I do.
And do you have experience with custody arrangements?
Extensive.
In your practice, how many divorce actions would you say you've been a part of?
Over 2,000.
How do you get new clients in your practice?
In this town, word of mouth, typically. I haven't really ever advertised. We've done some hometown parades back in the day, but was really more for team building, office building. I don't advertise in the newspaper or radio or anything like that.
And I didn't ask you this, and I should have, but what geographic area do you typically practice in?
Typically Park City, Wasatch County area. On occasion, I'll have cases out in the basin. Sometimes I have to go down to Salt Lake, not often, but I have some people who won't take no for an answer with leaving some in Wasatch County.
Understood. And so tell the jury a little bit about your process when you take on a new client, what happens in your office, and then eventually how you get involved with that person.
So we have I think I'm a bit unusual as divorce attorneys go. We have a very strict process that we have developed, we being me and my paralegal, Leslie Staples, who's been my paralegal, we're going on 28 years now this March. And we determined pretty early on in our practice that there was a lot of information we needed to receive from clients in order to get a case going. So I developed forms that we use in every single case. When I'm meeting with client, I've developed diagrams. In approximately 2008 is when we really started putting things together so that every client meeting could follow the same pattern, the exact same order for the most part, and I could take all of that information, hand it to my paralegal, and she would know as much as I did at the time with regard to some basic information.
So if a new client was being referred to you, would they first set up a meeting with your paralegal via phone?
Yes. She has vetted clients since we started practicing together. If I vetted all clients, I wouldn't get any work done.
And so after that call with your paralegal, do you meet with the new client?
If they get past Leslie, then yes, she will schedule a meeting for me. Almost every new client, especially if they're at the beginning of a divorce case, she tells them that the meeting can be anywhere between 2 and 4 hours, depending on the complexity of their case. Like I said, my process, I think, is pretty unusual because I try and get as much information as the client knows or can give me, and I give them back as much information as I can to make that initial meeting really impactful because it's getting divorced is a very emotional process in addition to a legal process.
And so during that, or I should say after you have that intake meeting, this extensive meeting with a prospective client, new client, or with a new client, how many people actually, in your experience, proceed from that meeting to filing a divorce?
Based upon my 30 years, almost every one of them. There are a handful that don't, but the process of emotionally, psychologically, finally calling a divorce attorney and then the process of showing up for a meeting is significant for most people. Once they've kind of hit that stage on an emotional, psychological standpoint, they're ready to move forward or ready to prepare to move forward. So, I mean, there have been people I've been meeting with for 10 years who have yet to move forward, but there are rare. It's rare that they don't move forward, either with me or someone else, or something happens.
And in those rare occasions, what are some of the reasons that those people give or that you experience that they don't move forward with a divorce?
It's pretty specific to each individual client who's not moving forward, but the top reasons are they're concerned about kids, the impact of divorce on kids. They're concerned about the age of their kids and being too young to be able to speak up about what's happening in both households. Some people are concerned about their religion and what it means for them from a religious standpoint. Some people have stayed together for quite some time because of health reasons. Back in the day when it was more difficult to get insurance, you would have some people who had a significant health issue who stayed together until that health issue was resolved.
And so you've kind of talked about this extensive first meeting that you have with new clients, and part of that, it sounds like, is information gathering from that person. Is that correct?
Yes.
And you've talked a little bit about the forms that you go through. Are one of those forms directed towards, or the topic of that is any children involved?
Yes. So my office staff, I'm sure, gets annoyed at the fact that I like to have all my forms in a very certain order. And like I said, I'm a visual learner. That's how I teach people about divorce. So I have the diagrams I have and what I call the blue sheets, which are sheets that have all topics on it that I feel like I need from most divorcing people. They go in a certain order. So my packet, when somebody comes in to meet with me, it's thick, and it goes in order. So it's first, what is divorce and what does this path look like? Then it's kids, and I have forms and booklets and reading material and the Children's Bill of Rights that we go over. And then there's assets and debts, and then it's ongoing issues. So if alimony may be a concern, we go over a diagram for alimony and hit a lot of topics on income, expenses. Then there's miscellaneous, and then we go over what does this path look like if you went this way? How do you tell your spouse? How do you prepare for ultimately filing or defending?
I want to turn your attention to Eric Richins. Did you know him?
I knew him in the sense that I met with him.
And how did you come to meet with him? Who referred him to you?
Several people, but the person that reached out to me was his brother-in-law, Clint Benson. He texted me in early October 2020, asked if I could meet with his brother-in-law, Eric, and told me it was urgent. So I explained the process that you have to get through Leslie, and I believe he contacted the office early October 2020, and I ultimately met with him October 23rd, 2020.
Okay, so Eric went through the process that you've described and ultimately ended up with you in that extensive new client meeting that we've been discussing.
Yes, we met for 2.5 hours.
While Eric was with you in that meeting, did he fill out the typical paperwork? Did he go through that packet that you've been describing?
Yes.
Okay.
He left the packet at my office. He didn't take it with him. We have a bound binder, for lack of a better word, that people take this packet of information home with them and read it. Eric did not.
Okay, give me just a moment.
This is our state's Exhibit 8-49. If you could turn to the 8th tab.
Okay,
Do you recognize that?
I do.
And we've been talking about paperwork that Eric filled out. Is that some of the paperwork that he filled out in your office?
Yes. That, just so you know, under adverse party, where it says Kouri Richins, Darden in parentheses, that's my handwriting, and it's my handwriting at the bottom in the kind of grayed out box.
Okay, and the rest of that is paperwork that Eric filled out?
Yes.
Okay. That's all we need from that one for now. So I want to talk about the advice that you gave to Eric Richins during this meeting. Did you get an impression about why Eric was in your office?
I did.
What was that impression?
He was there to find out what it would look like in terms of going forward with the divorce. Was there to learn how to protect his finances, having just...
I'm going to object.
Pause
This
there, Ms.
information
Miller.
is all based on hearsay.
Are you asking about what was said or her observation of his physical demeanor?
I'm asking about effect on the listener, Your Honor, how his information informed her legal advice.
Please approach.
Sure. During your meeting with Eric, did you give him legal advice about custody?
I did.
Describe, in 2020, what was the presumption when someone was contemplating divorce about how custody arrangements would work?
At that time, well, let me start with when I first started practicing, way back when. It was the old Ward and June Cleaver thing with regard to custody. Somebody had most of the time and the other person had weekends. There has been a wave through the legislature, through child psychologists, with regard to child psychologists focusing on what's in the best interest of kids, and the legislature listening to lobbyists. I was on the executive committee for the family law section of the Utah Bar at the time, so we closely watched what was going on in the legislature. So at that time in 2020, there had been a statute passed about 5 years previous that finally had an alternative parent time schedule that was more of a 60-40 type schedule. We called it fat weekends, but that is where courts were going. Courts, judges, custody evaluators were all trending towards equal parent time, 60-40 parent time, and so forth. So by 2020, this was October, there were already rumblings of a new statute being passed that would be an alternative statute for 50-50 parent time. That all these statutes have been renumbered in 22, but at that time that was 35.2 or going to be 35.2. But when I met with Eric, we had 35.1, which was this fat weekend. So I talked to him a lot about this is typically what happens with kids in going through a divorce. Unless there is something really that stood out, almost all judges were going with more of a joint physical custody situation.
And so you explained that potential situation to Eric Richins.
right off, yes.
And without saying if he had a verbal reaction, could you tell how he reacted otherwise?
Yes, we had no further discussion about custody or all of the other things that would go with custody, where I would typically get into with clients specifics about what holidays look like, what a full year calendar looks like, whether there are meaningful holidays in their family, what the right of first refusal looks like. I have on my blue sheets, it's 2 pages, and I would, in most cases, I fill out both of those pages.
Did you do that with Eric Richins?
No, I didn't.
Was that unusual?
It is unusual. It is unusual for me not to continue down the path of a custody conversation, and it typically means that, well, in every case, I think that I haven't filled that out. It meant the client did not want to think about, for whatever reason, did not want to think about the possibility of not seeing their child every day, or the possibility of the other side having their child more often than them, or an equal amount as them, and so forth. But
at the conclusion of your intake meeting with Eric Richins, did you give him a to-do list?
I did.
And when you give a client a to-do list in your practice, does that mean that a divorce is imminent?
Typically, yes. I've been around a long time, and this is a small town, small county, and so there are people that will come and meet with me to try and conflict me out of a case. And after so many years of practicing, you learn pretty quickly that that's their intent, because they want to take our 3 or 4 hour meeting and do 15 minutes and call it good. Some of those people retain us. Others just want to know the information that I have, because, like I said, I'm trying to teach them all about divorce and what life looks like after divorce. So
giving the to-do list, how is that significant in your practice? Would you give that to someone who wasn't going to proceed?
No. If I have somebody that comes in and they're either trying to conflict me out, or they just really want to talk about what this might look like in 30 years down the road, there's no to-do list. Sometimes I won't even fill out the questionnaires that I have, the question papers, the blue sheets. But if they have a to-do list, people are, in my experience, it is anticipated that they are going to file for a divorce at some point in the future.
And Eric walked out of this meeting with a to-do list from you.
He did not want to take it with him.
Oh, that's right. He didn't leave it, but you gave him a to-do list. Is that right?
He wanted me to correspond through his brother-in-law, Clint. So I emailed the to-do list to Clint.
Did you refer Eric Richins to anyone after or during your meeting with him?
I did.
Who did you refer him to?
He had worked in the past with Crystal Bowman Carter to do his business planning documents, and he needed to revoke a power of attorney. So he was going back to Crystal for that, or I told him to go back to Crystal for that, and also to redo an estate plan.
Okay. Was it unusual in your practice to refer someone in Eric Richins' position to a lawyer like Crystal Bowman Carter?
Yes.
Why is that unusual?
Because most people going through a divorce, in my experience, aren't thinking beyond what that divorce might look like. They're not thinking about death or estate planning and so forth. And most people, once you file for divorce, you cannot change any beneficiary and so forth. And so That was not a rule at that time in 2020. It's a rule now, but it was unusual. I've only referred one other person in my memory to change their estate plan while a divorce was either pending or before they filed for divorce.
So Eric went through this initial meeting with you. Did he ever file for divorce with you?
He didn't.
Or through you, I suppose?
No.
And did you discuss a timeline with him about filing for divorce?
I did not discuss a timeline with him. As I said, well, I didn't say this, but because divorce is so emotional, and there are so many things to unravel, kids and finances and debts and family and external family and extended family, and everybody really is on their own timeline. Like I said, I have a couple clients currently that I've been meeting with them for 10 years off and on, so they're not ready to pull the trigger, and everybody has a different timeline.
Thank you. Those are all my questions for you.
Good morning, Ms. Miller.
Morning.
My name is Wendy Lewis. I am one of Ms. Richins' attorneys. So, I think you stated on direct already, but it wasn't Eric Richins that reached out to set up an initial appointment with your office, correct?
That's correct.
It was his brother-in-law reached out, and not just to say, hey, I'm referring someone to you, but he reached out to set up the appointment, correct?
I don't recall whether, I wouldn't have been part of that conversation. That would have been with Leslie, my paralegal.
Can we take a look at CM1, just for the witness? Let me see if that's the right one. Okay. Let me just ask another question before we talk about that document.
Sure.
Two more questions. So you do remember that it was Mr. Benson that reached out, and then you set up a meeting with Eric. Did anyone attend that meeting with Eric, or was it just yourself and Mr. Richins?
It's my understanding Eric contacted my paralegal to give her a lot of specifics about his situation, and then the meeting that I had with him was just the two of us.
All right. And after that meeting, it was Mr. Benson that reached out and thanked you for meeting with Eric, correct?
Yes, Eric did not want me to have any contact with him via phone or email directly. He wanted everything to go through a third party, his brother-in-law.
Okay, that's what I was getting to. So when you gave Eric the list of documents, you actually sent that to Mr. Benson.
That's correct.
And then it was actually Mr. Benson who provided you with the documentation over email. I don't know, Eric may have brought some things in person, but anything that came over email was between you and Mr. Benson, correct?
Correct.
And would one reason that a client would ask for that, would it be because they weren't ready to let the spouse know that they were considering divorce? Is that fair to say?
Yes.
All right. And a reason for this, and I mean, I know you said that most people who come in and go this far do end up filing for divorce, but fair to say that some people aren't certain if they're going to file when they come in to see you, correct?
Very few.
It happens, though.
It does happen, yes.
All right. And you testified that you went through custody arrangements with Mr. Richins, correct?
Yes.
And you went through the forms you went through regarding children involvement in divorce, correct? I might be naming that form wrong, but you said you went through forms about children.
Children's Bill of Rights.
The Children's Bill of
Yeah,
Rights.
it is not an official thing in Utah, but I have it, and I give it out on it. I'm very color coordinated, so I've colored pens for various things, colored paper for the initial client consultation. That happens to be on purple paper, and it's taped up all over our office as well, so I can remind clients, this is the sun, your kids are the sun, and we are all rotating around them, so let's keep our eye on the prize. So it's just, it isn't anything you could enforce in court, but it's something that I like to share with clients.
Sure, because clients with small children, that's a huge consideration, is what will happen with the children, both financially and emotionally, and who the children will be living with. Fair?
Typically not financially, but emotionally, and who they will be living with and what the possibilities are, for sure, is a big concern for most people.
Okay. Finances are a concern, which is why you fill out a child support form with clients, correct?
Yes.
And can you pull up CM 5? And you filled out a form with Mr. Richins about child support, correct?
I did, yes.
And he reported to you at that time his monthly income was $33,333, correct?
That based upon what, yes.
Okay.
Sorry, I was gonna say, I didn't have documents at the time, so we were just, this is more for kicks and giggles of, this is what child support would look like if this were the number.
Fair.
Yes.
And his child support was going to be high, correct? Based on his income?
Yeah, well, I mean, it depends on who you're thinking about. In Park City, probably
You're
not so much,
absolutely
but
correct.
for most people,
That's
yes.
true. In my very small dalliance with divorce law,
Yes.
you see people whose income it's quite low. I'm going to say frequently. Some people it's quite low, and child support's not very much.
You can have that for sure.
And for some people, this is a lot of people. $33,000 a month is a high income, correct?
Not for a lot of people that I deal with, but I think on the
fair.
whole, yes.
All right, you're dealing with some more, maybe fair to say, that didn't come out very well, high-end clients, high-end divorces with more assets.
I would say the longer you're in practice, the more difficult your cases become, and the higher the wage tends to be with regard to divorces.
Okay. Now, other things you discussed with Eric were assets.
Yes.
Fair. And you were made aware that he was a partner in.
Objection, Your Honor.
I'm just asking if she's aware.
Forgive
May
me,
we
what's the
approach?
basis of the objection? Sure.
It's hearsay.
Okay.
So in consulting with Mr. Richins and receiving documents from Mr. Clint Benson and maybe from Mr. Richins, you became aware, or were you aware, that Mr. Richins owned a couple of businesses?
I became aware of that during my conversation with Eric.
Did you become aware of that in any way through documents, tax information provided, other documents provided to you by either him or his family?
I did not receive any tax returns from Eric Richins.
Did you receive anything, documentation, in terms of his businesses?
No.
Can
You mean
I,
the business specifically?
yes.
No.
Or that the businesses existed?
Yes,
Documentation that the businesses existed?
correct.
Okay. And one of the businesses was C&E Stonemasonry, correct? Do you recall that?
Yes.
And Katie, can you just pull up? Good question. The next one. I think it's maybe CM6 or 8. I don't know. Help me out here.
What page were you
Here, one moment, Your Honor. CM7. So you became aware that he owned partner in C and E stonemasonry, correct?
Yes, so this document,
Well, that's just to refresh your
oh,
recollection.
got it, okay.
Okay.
Yes.
And you also became aware through,
I need you to ask the question to lay foundation for the how about the other businesses
I was about
as
to.
we discussed. You
I was-
can't ask it as a leading question.
all right. Let me back up a little bit. You said through documentation you became aware of Mr. Richins' businesses, just that they existed.
The masonry business.
Did you receive documentation that he and Kouri Wright were also partners in another business?
No,
You did not receive any documentation about any businesses existing, just the existence of the businesses?
Asked and answered,
No.
Judge.
Okay, well,
Overruled. Now we have double confirmation. Please go from there, Ms. Lewis.
okay. Did everybody hear the whole?
I think it was 2 no's in a row,
Okay.
but
All right. Let's see. So now, I know Ms. Shervanack asked you, and you said it was true that Mr. Richins did not proceed with divorce in this manner, in this case,
not
correct?
prior to his death, no.
Right. And to your knowledge, he did not proceed with divorce with a different attorney, fair?
Correct.
All right. And you said that you referred him instead to an estate planner, estate attorney.
Didn't
An attorney who
refer,
does estate planning. Thank you, sorry.
didn't refer him instead. I just referred him to Crystal Bowman Carter to work more in tandem.
All right. And you said you haven't done that very many times, correct?
Right.
But there would be reasons to refer someone to an estate planner, fair? Just, would there be reasons, yes or no, and then I'll follow up.
At the end of every divorce case, I refer every client to, I give every client a very long, again, to-do list and a closing letter. And at the end of that closing letter, I refer everyone to, or I recommend that everyone see an estate planning attorney to
Okay.
revise their estate planning documents now that they are no longer married.
Okay. In this case, however, that happened earlier in the process than normal.
Yes.
All right. And just, let me ask you a hypothetical.
Sure.
So sometimes people have concerns about their children. I mean, it's a fair reason that people don't get divorced when they have small children because they don't want to break up the family. Fair?
Yes.
All right. And if an individual has concerns about providing, well, let me rephrase that. So hypothetically, someone may have concerns about how their children will be provided for after a divorce. Fair?
Provided for
Financially.
psychologically or financially?
Well, both, but I'm talking about financially.
Yes.
All right. So one reason someone may go to an estate planner could be to ensure that things were properly set up to provide for their family, whether they get divorced or not. Fair?
Are you talking about this early on in a potential divorce proceeding or just generally?
I'm asking hypothetically, well, generally first.
Yeah, people generally go establish an estate plan to make sure that if they have children, their children are taken care of, or that if they have assets, their assets are allocated the way they want upon their death.
Okay. And even though you said it's unusual, it's certainly possible that as someone is going through talking about divorce, they discover that they want to look at this now. Prior to divorce, they want to set this up. Part one of my question, is that possible?
I have never seen that, but I assume anything is possible.
Sure. And it's possible that someone may decide, instead of a divorce, I need to set up a way to make sure my family's taken care of, then maybe that's the more appropriate thing for me to do at this stage. That's possible.
I think you're probably comparing apples to oranges. When, in my experience, when someone is ready to move forward with a divorce, or when a divorce has been kind of forced upon them from their other spouse, it is because we have, I explain it to clients as two pieces of wet noodle, and we drop them on a plate, and one is the emotional divorce and one is the legal divorce, and my job is to straighten those out and keep them as separated as I can, because at touch points, when the legal divorce touches the emotional side is in chaos, and when the emotional side touches the legal side is in chaos. And so when you're going through a divorce, that in and of itself is an apple, where people are worried about what their kids' lives will look like tomorrow.
Understood.
Or next month. When you are doing estate planning, it is, what will my kids' lives look like if I am not here, or me and my spouse are not here? Like, is grandma going to take them? Is my sister going to take them? And so they don't often overlap, because people in divorce don't often, in my experience, they don't even really think about their estate plan. It doesn't come up in our cases, except for a very small handful of cases.
I understand it's a very small handful, but let me just try and ask once more.
Sure.
It's possible that while going through what a divorce is going to entail, someone can change their mind, correct?
Decide not to get a
And
divorce?
decide not to get a
course.
divorce, correct? And then it is possible that they want to go set up an estate plan, correct? I mean, that can happen.
I'm sure it can. I've never seen it happen, but I'm sure it can.
Okay. You don't, okay, I'll strike that. All right, but that's what happened here. Mr. Richins decided to see an estate planning, a lawyer who specialized in estate plans, correct?
What happened was, I advised him to seek an estate planning an attorney to help him with what I perceived as his concerns at that time with regard to his finances and his children.
Okay, thank you. I have nothing further at this time. Thank you.
Ms. Sherman,
No other questions, Judge.
may we release this witness?
Yes.
Ms. Lewis, may we release this witness?
Yes, Your Honor.
You're free to go.
Thank you.
Nice to see you.
Thank you.
Mind taking that cup with you?
Of course.
And your phone. Leave the binder there if you don't. Oh, is that your binder?
No, you can leave it there. Okay.
Thank you. Take care, Ms. Miller. Counsel, any objection to breaking for lunch?
Whatever the court wishes.
Ms. Lewis?
No, Your Honor.
Okay. Folks, please rise for the jury. During the break, ladies and gentlemen, same instructions. Don't talk about the case. Don't read, watch, or listen to anything about the case. Do not do any research on your devices about the case. Please enjoy your lunch. We'll come back at